Today, we are going to get right into the nuts and bolts of what makes Canada, well, Canada. We're talking about federalism, and I want you to think of it not as some dusty old concept from a textbook, but as what it really is, a grand and very much ongoing experiment in how you run a country.
So let's go back to the beginning, to 1867. The founders of Canada had this massive puzzle on their hands. You've got these different colonies with totally different histories, economies, cultures. So the question was, how on earth do you stitch all of that together into one single country without just steamrolling everything that makes each region unique?
And the solution they came up with was federalism. It was a pretty ingenious answer, really. Instead of an all-or-nothing choice between one super powerful central government or just a loose collection of separate provinces, they decided to split the difference. They divided up the power, creating a system where a national government and regional governments could both exist and both be powerful in their own right.
Now, this wasn't just some neat theory they came up with. No, this was a tough, hard-fought political compromise. And to really get Canada today, you have to understand this original bargain.
You can almost picture it as a tug of war. On one end of the rope, you had leaders who wanted a single, strong, centralized nation. But on the other end, you had powerful provinces, especially Quebec, with its own language and legal system, and the Maritimes with their own economies. And they were saying, no way are we just going to be absorbed and disappear. Federalism was the middle ground. It was the bargain that let both sides drop the rope and agree to build a country together.
So how do you make a deal like that stick? Well, you write it down, you create a blueprint, and that's exactly what they did in the Constitution, with a very specific division of powers.
So the Constitution Act of 1867 basically created two big buckets of power. In the federal bucket, for the government in Ottawa, they put all the stuff that affects the country as a whole, right? Things like the military, banking and currency, criminal law, you get the idea. And in the other bucket, for the provinces, they put things that were seen as more local, stuff like hospitals and healthcare, education, and how cities and towns are run.
Okay, but here's where it gets really interesting. The rule book had this one little phrase giving provinces power over property and civil rights. Sounds pretty specific, doesn't it? But over the years, the courts interpreted that phrase so broadly that it now covers a huge chunk of our modern lives. Everything from consumer protection laws to environmental rules and labor standards. This one little phrase became a massive source of provincial power.
And that brings us to the referees in this whole system. If you've got the federal government and the provinces as the two teams, you absolutely need an umpire to make sure everyone is playing by the rules. In Canada, that umpire is the court system. And the main tool these umpires use is something called judicial review. It's actually a pretty simple idea. The courts can look at any law, whether it's from Ottawa or a province, and ask one basic question. Did you actually have the power to make this law according to the Constitution?
And what happens if the answer is no? Well, the court blows the whistle and declares that law ultra vires. It's Latin for beyond the power. And a law that's ultra vires is basically null and void. It's off the books. It's a really powerful way to make sure neither team can just wander onto the other side of the field.
But here's the thing. The rules written down in 1867 are one thing, but the way the game is actually played on the field has changed a lot. The relationship between the federal and provincial governments has evolved from something like rivals into more of a partnership.
You know, right at the start, the system was designed for the federal government to be the dominant player, for sure. The provinces were kind of like junior partners. But then, in the early 20th century, court decisions started giving the provinces more and more clout. After World War II, you see the rise of what's called cooperative federalism, governments actually working together on big things like healthcare. And today, a lot of the action is in executive federalism, which is basically the prime minister and the premiers getting in a room and hashing things out directly.
I mean, this just says it all, right? It's like night and day. We went from a top-down hierarchical model where Ottawa was clearly in charge to a collaborative system. The federal government is now more of a partner, and the provinces have become incredibly powerful autonomous governments in their own right. The whole dynamic has shifted from central control to nonstop negotiation. So this constant negotiation brings us to the ultimate stress test for any federal country, the highest stakes question of them all. What happens if one of the partners decides they want out?
So, here it is, the big one. Can a province just decide on its own, we're done, and declare independence? This isn't just a hypothetical question for Canada. It's a real legal and political storm the country has had to navigate.
Well, in 1998, the Supreme Court of Canada was asked to weigh in. And in a landmark case, their answer was crystal clear.
Can a province unilaterally secede? No.
But, and this is a huge but, the court didn't just slam the door shut. They actually laid out a roadmap. They said if a province holds a referendum on a clear question to leave and gets a clear majority yes vote, that creates a constitutional duty to negotiate. That means all the other governments in Canada would be legally required to sit down at the table and negotiate the terms of separation in good faith. The key thing is, a province can't just walk away. It has to be a negotiated breakup, finalized with a formal constitutional amendment.
What the Supreme Court did here was actually kind of brilliant. They managed to balance two of Canada's most important principles. On one hand, you have democracy, the idea that the will of the people has to be respected. But on the other hand, you have the rule of law, the idea that you can't just ignore the Constitution, which is the fundamental rule book for the whole country.
So let's wrap this all up. What are the big things to remember? First, Canadian federalism is the country's unique solution for managing unity and diversity at the same time. Second, the Constitution is the blueprint, and the courts are the umpires making sure everyone follows it. Third, the system isn't static. It has evolved from a parent-child relationship to a partnership of equals. And finally, even the most extreme test, secession, has a set of constitutional rules that balance democracy and the law. And all of this leaves us with one last big question to think about. This whole system was born from compromise, and it survives through constant negotiation and change. So the question is a country that's built on a foundation of never-ending compromise strong enough to last forever? Well, that is the question at the very heart of the grand Canadian experiment.